All right, well, hey, let's go ahead and get started. First and foremost, good morning, good morning, good morning. I hope everyone has had a wonderful start to their week. Already in February. I feel like first quarter of the new year's going by fairly quick, or maybe it's not for some of you. So today we are going to be talking a little bit about the Corporate Transparency Act, a federal law, and what it means to you, either as a manager, management company, or community association board member. First and foremost, my name's Clint Brown. I'm with the law firm Roberts, Markell, Weinberg, Butler, Haley, and I am a shareholder and kind of run the Property Owners Association division for our law firm across the state, of course, with Mark Markell. So let's go ahead and get going. And as it relates to kind of questions, please feel free to type them in as they pop up as I'm going through this conversation. But I'm going to be addressing the questions at the end. But again, you type it in now so that when I start addressing questions, I'll hit yours first. So I'm just kind of go down the line once we get into Q&A. As mentioned, I'm going to try to keep this presentation about 40 minutes. So I'm hopeful around 12:10, 12:15, I'll be able to stop and move over into Q&A. I am an attorney. Attorneys like their legalese and disclaimers. So here's one for you. The information presented today is based on the law as it exists today, February 20th of 2024. That's especially important when we're talking about the Consumer Transparency Act. You'll see why here in a minute. Additionally, this information is presented for educational purposes only and does not constitute legal advice. If you need legal advice relating to any of the topics discussed, please consult with your attorney. With that, let's dig in. Okay, Consumer Transparency Act. I'm going to refer to it as the CTA because it takes too long to say Consumer Transparency Act. Our agenda today, why was the CTA passed? Who is this beneficial owner? Who reports the beneficial owner information? What must be reported? When must the reports be filed? Who can access this information? What are the penalties for noncompliance? That's a scary subject we're going to be hitting on. And then finally, what do we do? What now? Who, what, where, when, why, how? How do we navigate this new federal law? So that'll be what we're hitting on today. Let's dig in. Okay, Corporate Transparency Act, 31 USC Section 5336. It was enacted back in January 1st of 2021. So it's been around for some time. But we really didn't start getting articles and interest until last year, so back in 2023, because the final rule was kind of implemented and effective last month, January 1st of 2024. In a nutshell, summary, the CTA requires reporting of beneficial ownership information to the U.S. Department of Treasury's Financial Crimes Enforcement Network. Here's another acronym for you, FinCEN. So that's what I'm going to be referring to as well. Yes, Corporate Transparency Act. If I said consumer, I'm sorry. Corporate Transparency Act. So why? Why do we have to report this beneficial owner information? Gaps in national security due to lack of this sort of information, right? Who are the owners of these entities that are formed throughout the country? So the U.S. has had issues with kind of these shell corporations. So a corporation inside of a corporation inside of a corporation doing organized crime, right? Engaging in criminal activity. Additionally, other big players in the world economy, the UK, the EU, they all have similar regimes in place as it relates to reporting this information. So, lack of centralized database, this shell companies committing fraud, other illegal activity, all precipitated the passing of the CTA. Designed to provide accurate, complete, and highly useful information to law enforcement authorities. So that is why the CTA was passed. Who must report? Who must report? Okay, first and foremost, what is a reporting company, a domestic reporting company, or a foreign reporting company? We're going to be dealing with domestic reporting companies. It is a legal entity, that is a corporation, a limited liability company, or an entity created by the filing of a document with the Secretary of State in the law of the state of Texas. We're dealing with Texas today. Well, the first example, a corporation, guess what community associations are? They are nonprofit corporations. So, associations, so far, we are a corporation. All right. So, you are a domestic reporting company. That's step one. Association is a domestic reporting company. Let's go to the next step. Let's keep on going because this really doesn't apply to us. All right. Who must report? There are exemptions, 23 exemptions, and I'm going to hit on some of the big ones. Actually, I'm just going to focus on one of them because it's really the only one that is going to be applicable to community associations. If your association, your HOA, POA, condo, well, not condo, never a condo, if you are a 501c corporation and exempt from taxes, then you are exempt from the CTA. So what kind of 501c entities are we talking about? It is typically very large community associations that received 501c exempt status from the federal government and then use that to become sales tax exempt in Texas. If you are one of those 501c nonprofit associations or corporations, you are exempt from the CTA. I'll say from a practical standpoint, very few community associations in the state of Texas are 501c. Regardless, if you don't know or believe you may be 501c, I encourage you to reach out to your legal counsel so that he, she, or they can look it up and give you some legal advice, whether or not you're exempt from the CTA. Again, I'll say the vast majority of associations in Texas don't get to enjoy that exemption, but it doesn't hurt to take a look. All right, here's another example or exemption that could apply to basically self-managed large associations. You've got to have more than 20 full-time employees. Got to have a physical office presence. Again, if you're a very large association with your own management, self-managed, well, then you're going to have your own office space. And you've got to have more than $5 million in gross receipts or sales reported on the prior year federal tax return. So you've got to look at all of that. And that 5 million may be a problem for most communities here. So again, very narrow exemption. I doubt it's going to apply to many, if any, community associations in the state of Texas. But again, it is something to look at if you are a large self-managed community. All right, so step one, community association, you're a reporting company, period, end of sentence. Well, again, unless one of those exemptions apply that I just went over. So what do you have to disclose? You've got to disclose information about the reporting company, information about your beneficial owners. Okay, what is that? We're going to define that term. Information about company applicants. Again, another term of art we're going to define. And then finally, individuals may obtain their own FinCEN number to use on the reporting company report in lieu of identifying information. So again, getting a FinCEN number to bypass that and then just attaching it when you do your report. Okay, information about the company. Entity name, the legal name, any trade names y'all use, doing business as names, basically. Your current street address. I can't use a PO box or address a formation agent or a third party. So again, your managing agent is typically what we try to use. So we'll have to look at how best to address that. Again, getting with your counsel, the state of formation, Texas, and then your EIN number, all fairly easy information to obtain and report on. Okay. If you are a beneficial owner, and again, we're going to define that here in a minute. If you are a beneficial owner of the community association, you must give your full legal name, your date of birth, your current residential street address. So you cannot use your management company's address. It's got to be your home address. And then a unique identifying number from your passport, if you have one, or your Texas ID or Texas driver's license. And whatever number you give, you have to give an image of that document. So an image of your passport ID or your driver's license. So that's it. I mean, literally, if you were close to a scanner at your office or wherever you are, you could get this done in 5 minutes. So it's not the time it takes to report that's the problem. I'll talk about the problem here in a minute. So that's what a beneficial owner has to report. Okay. Who is a beneficial owner? What are we talking about here? I'm not an owner of my community association. I'm just a volunteer board member, right? Fortunately, wrong as it relates to the definition of under the CTA. Beneficial owner is defined as any natural person who directly or indirectly so it's either or, exercises substantial control over the reporting company or owns or controls at least 25% of the ownership interests of the reporting company. The 25% rule really, it doesn't apply to board members. You don't really own it. Control, maybe if there was just four board members, but the second example really doesn't apply. It's exercising substantial control. What does that mean? Substantial control. Here's the definition. Serving as a senior officer of the reporting company. Here's some definition of senior officers. Individual holding the position or exercising the authority of your president. So a president, okay. President is a beneficial owner. Your chief financial officer, that's probably your treasurer. So your treasurer is covered. Any other officer, regardless of title, performing some sort of similar function. So again, your COO, is that your secretary? Procedural matters. So again, all officers are likely going to be considered beneficial owners. Here are more substantial control definitions. So directs, determines, or has substantial influence over important decisions made by the reporting company. And then there are some examples of major or important decisions made by the reporting company. Big picture is this. You're a board of 5 board members. Your association wants to spend $40,000 on a project. Who approves that? The board, all 5, right? Or a majority of a quorum at a board meeting. So every single one of you exercises substantial control over the community association. That means that every board member is going to be considered a beneficial owner for purposes of reporting. So association is covered by the CTA unless one of those exemptions applies that I mentioned. And all of the board members on the board of the association are considered beneficial owners. Sorry for the bad news. So again, just other examples of substantial control, but again, every board member is going to have the opportunity to exercise substantial control. Okay, here's some exemptions. Doesn't really apply. Okay, what must be reported about company applicants? Reporting companies do not report company applicants if formed before 1/1 of 24. If formed on or after 1/1/24, the company applicant, who is the company applicant? It's our law firm. If we're providing this service for our client, we are a company applicant, which means we are subject to liability provisions similar to beneficial owners. So company applicants, so if we're filing it, we have an obligation, our law firm has an obligation. If one of our paralegals or me, the attorney, I've got to disclose my full legal name, my date of birth, my current residential street address or business address, and then, of course, that unique identifying number with a copy of the passport or driver's license or ID. So the same information that a beneficial owner has to disclose. If a company is engaged in providing this service to their client, they have to provide this same information as well. So, definition of company applicant: the individual who directly files the document that creates the reporting company. The individual primarily responsible for directing or controlling that filing. So again, if our law firm has a paralegal that files and an attorney reviews it, both the paralegal and the attorney have to report that information, that full legal name, et cetera, et cetera. And it's limited to no more than 2 individuals. Okay. So again, already talked about this. The attorney and the paralegal are both considered company applicants. Same thing with a management company. If a management company decides to offer this service, they are considered company applicants, and they have to report that information as well. When do we have to get this done? What are our deadlines, right? So this is the big issue here. Again, if you did it yourself, it'd take 5 minutes. But the problem is getting all 5 board members to do it, or 3 or 7, however many board members you have. If your community association was in existence, before January 1st of 2024, you must file no later than January 1st of 2025. There's an asterisk I'm going to hit on here in a minute. So we've got roughly 10 months and some change to get this filed for entities that were in existence before January 1st, 2024. If the entity was formed on or after January 1st of 2024, but before January 1st of 2025, you must file within 90 days of the earlier of the date the reporting company receives notice of creation, or the date when the Secretary of State first provides public notice. So for those community associations, this is more developer control, right? Developer forms community associations when they start building their development. The minute we get that Secretary of State filing back saying, hey, y'all are a formed entity now, here's the entity name, that's when that 90-day clock starts ticking. So you've got to be sure to get that sensitive information input with FinCEN as soon as possible, because you've got that 90-day clock ticking. Now, if you are an exempt entity, one of those exceptions I went over, but then you lose your exemption, you've got 30 days to do your filing. Now, here is the caveat. House Bill 5119 has already passed the House, It's in front of the Senate and the president still as of this morning when I looked it up. If this House bill becomes law, it will give us an extension of the deadline to January 1st of 2026. So that'll give us a year, 10 months, and some change, which would be wonderful. However, that is not the law right now. We've only passed one body of the federal government, the House. We still have the Senate and the president to go through. But if it passes, it will extend our deadline, and then it will allow for a 90-day clock to provide any updates to our information or basically our initial filing. It makes that 90 days permanent, because currently the 90 days is temporary and it reverts to, I think it's 60 days. So we're hopeful this bill becomes law. We'll see. Okay. When must reports be filed? Okay, what happens if there's a change in the beneficial owner, or a change as it relates to the company, the reporting company? Well, you've got to update it within 30 days of the change. You've got to update that within 30 days of the change. So, example, we've got a board of 5. 2 of the 5 board members are up. Their terms are up. And we've got our annual meeting in November. We get 2 new board members on, November 30th. Well, from November 30th, you've got 30 days to update your FinCEN data for those 2 new board members. Just those 2 new board members. All right. Okay. If there was an error made, you've got 30 days to correct that error when you become aware or have reason to know of the inaccuracy. So if you make an error and then you find out about it, you've got 30 days to find out about it. And as long as you do it within that 30-day period and is filed within 90 days after the date on which the inaccurate report was filed, then you get to enjoy safe harbor and are not subject to any civil or criminal penalties, which I will talk about here in a minute. Okay, who can access this information, this beneficial ownership information? FinCEN is legally required to store your private information in a secure, non-public database. Federal government likes their acronyms, the Beneficial Ownership Secure System, or BOSS. FinCEN may disclose this information only on receipt of a request made by U.S. federal agencies engaged in national security, intelligence, or law enforcement, state, local, and tribal law enforcement agencies, but you've got to have court authorization for them. Federal agencies on behalf of a non-U.S. law enforcement or foreign prosecutor or judge, financial institution, and then federal and state regulators. So basically, they're saying this is secure. BOSS is secure, and they are not accessible to the public and are not subject to Freedom of Information Act requests. Take that for what it's worth. Okay, failing to, this is the scary part, right? Okay, we've got to do this new reporting, and if we don't do it timely, we're in violation. So what? Here's the problem. And this applies per beneficial owner, a civil penalty of $500 for each day that a violation continues and has not been remedied. So we've got 5 board members, $2,500 a day until it gets fixed. Criminal fine of up to $10,000. Imprisonment of up to 2 years for failing to file this beneficial ownership information. This applies to our law firm. If we are provided the information and for whatever reason, just don't file it. Just, it was a mistake, a accident. We're subject to this. We're subject to liability as well. So whoever files these is subject to liability as well. Okay. If you disclose or use the beneficial ownership information, you are liable for civil penalties, $500 for each day that the violation continues and has not been remedied, criminal fine of up to $250,000 and or imprisonment of up to 5 years. You can have enhancements of $500,000 and 10 years if done while violating another U.S. law or a pattern of illegal activity. So this really applies to the company applicant that receives this information from the board members and then misuses it in some way, shape, or form. These are more penalties that company applicant can be subject to. So again, lots of liability potential for both the beneficial owners individually, the community association, and then the person or law firm or whoever filing the information with FinCEN. What do we do now? Okay, so these are our steps, and we've been kind of going through these. And then I'm going to talk about some kind of bigger picture problems or items we need to think about. So this is all through whoever you use, whether it's your law firm or your management company or another third party. Your step one is, hey, are you a reporting company? Step two, who are our beneficial owners? Are they or the reporting company exempt from reporting? If the answer is your reporting company, your beneficial owners is your board, and there are no exemptions, then step four is you've got to gather the information on the beneficial owners, either through a third party or doing it yourself. Gathering information about the reporting company, again, either through a third party or yourself. Determine who that company applicant is going to be. There are times when the beneficial owner is also the company applicant for their own stuff. There's ways for you to do this yourself. And then somebody's got to file it on behalf of the company, of the community association. And then you basically gather that info and you get it filed. So, kind of big picture, move on to the next slide. This is questions, but before we address questions, some big problems that I've seen and have been asked about. Okay, we've got this requirement. Yes, we have until January of next year to get this done. So if you're a board member and you know that you are not going to be running again and you're up for election this year, if you're not going to be running again, then as of January 1st of next year, you're not a beneficial owner, so you're not legally required to file the information. Legally speaking, you're not required to do it. Number two, we have our annual meeting in November. We have some new board members come on, or maybe it's the current board. And we tell them about this federal legal requirement. They look at you, they laugh, and they say, never. I will never disclose this information to the federal government. Period. End of sentence. You're not getting it. We tell them penalties. We tell them the problems. We email them. We keep a record. We send them emails. We send them formal letters from legal counsel, all telling them about the legal requirements and the penalties. And they refuse to get off the board, and they refuse to provide that information. What do we do next? Well, you've got to consider calling a special meeting of the owners to vote on that person's removal, because this creates liability not only for that board member, but for the community association, because you haven't filed beneficial owner information for all of the board members. So you've got to have a process in place to show that you've done everything in your power to get that board member to report, or to have them resign, or to have them removed. so that if and when FinCEN decides to pursue an action, we can show them that we have done everything we can to comply with the law as it relates to that board member. Another thing boards and community associations may have to think about is, do we amend our bylaws to add a provision that says in a nutshell, if a board member fails to comply with a federal or state law, that board member can be automatically removed from the board. So maybe we have to establish some sort of a removal process if they refuse to comply with federal law. All things community associations have to think about. Because again, going back to the beginning, to file this information, literally 5 minutes of your time if you've got a scanner close by. It's not a lot of work. It's the fact that you're going to run into situations where you either drop the ball, there's been a change in beneficial owners or association, and you don't update the information. That's where you run into these problems. And so it's going to have to be a new process and procedure that is just second nature. When a new board member comes on, he or she fills out a form, or they go to FinCEN themselves and file it. So it's all new, and we're trying to come up with options and remedies to make this as easy as possible. Oh, and by the way, I'm sure y'all get tons of volunteers to serve on the board as it is, right? It's a bit of a thankless job. Y'all are doing it to make your communities better, and it's sometimes just hard to get that volunteerism, and now we have this additional federal requirement. I know it stinks, and it makes it more difficult to kind of encourage volunteerism, but it's something we've got to live with. With that, let's go ahead and run through some questions. All right, good timing. We should have plenty of time to go through these. Okay, so one question from a manager. Hey, we management company have been advised not to do this because of liability reasons. It doesn't seem that complicated. Can you give your advice on this? So again, it's a decision that the management company is going to have to make. Is there liability? Yes, there is liability. If you drop the ball, do not file timely, only file partially, do not file correctly. Is it that difficult to do it right? No, it's not that difficult to do it right, but it's also not that difficult to mess up. So it's something that management companies are going to have to make their own decision on whether or not they offer that service and decide to help as a company applicant. As an HOA manager, are we considered a beneficial owner? God, that's a good question. So we actually looked at that, and ultimately, I really don't think you are. I don't think managers are beneficial owners because y'all do not exercise substantial control of the association. Because who do the managers take direction from in terms of contracts and all that, spending money? Who you take direction from the board of directors. You are not the decision maker, except in certain emergency situations as provided in the management agreement. So I think there is a good argument that HOA managers are not considered beneficial owners. So again, there are exceptions to every rule. There may be managers out there that do exercise substantial control and would be considered a beneficial owner, but most hypotheticals that are going through my mind, I do not believe that y'all meet that standard. But again, get with your counsel. This is just educational here today. I'm not providing legal advice. Next, can you confirm, is this for POA only, not applicable to condos? Ooh, wouldn't that be nice? Oh, this is just, nope. It applies to condos as well. So condominiums and single families, townhomes, all nonprofit corporations in the state of Texas, it applies. Are all of those necessary? So the greater than 20 employees and 5 million, Yes, that is an and, I believe. If we have time, we'll go back to that slide just to confirm. Oh boy, that's a good few. I thought we have to file private information for every homeowner. Boy, wouldn't that be a mess? Good luck. No, so this really only applies to the community association and the group of individuals that substantially control the association, which is your board of directors. Yes, the slides will be provided. Already answered that one. Yeah, I mean, willingness of people to run for the board. How do we tell our board members or candidates for that matter? Should we tell our candidates in our call for candidates that, oh, by the way, if you're elected, you're going to have to provide all this information to the federal government? It really is community by community, but maybe you treat this as a onboarding protocol, right? It's just included in an onboarding protocol that gets implemented the minute you get a new board member on. So there's different thoughts and decisions that need to be made both by management, the board, and legal counsel as needed. If a board member, the president, files the report, yeah, I mean, look, if you, the president, do your own reporting, right? You report your own stuff and you report the association info, well, you're also a company applicant then. So you are considered a company applicant. Is there a requirement to refile when directors change? Address that. The answer is yes. When a board member rolls off, is their FinCEN data removed? I don't know. I think it's kind of one of those things. Once you're in the database, you're in the database, but you're not going to be associated with the association when we update the FinCEN information, right? And Bob was on. Sorry, Bob, if there's any Bobs out there. But now Jill joins. Well, Jill is going to be taking the place of Bob. So I think the information is still there. I don't know what FinCEN does with it though. What if my home is owned by trust? So again, if it is your residential address, that's the address you list. If somebody was only on the board from 1/1/24 to 2/29/24, doesn't apply to that board member, right? Because you have until January 1st of 25 to file the info. So they're not on the board by the deadline. How are we going to get anybody on the board with this hanging over our heads? Again, working with each community, doing your best to try to get them to report and deciding when you want to disclose that, whether at the candidate stage or after a board member or a candidate gets on the board. It really just depends. Are association law firms offering these services? Yeah, I mean, our law firm is offering this service to our clients. There'll be information that's going to be provided only to our clients in the coming weeks. Again, it's not a service we offer to non-clients because of the liability, right? As a company applicant. And I imagine again, check with your counsel. So check with your legal counsel. He, she, or they will be able to provide you more information on applicability and whether or not they're offering a service to help with this with this initial filing. So again, yeah, this is a very good point. Amending your bylaws to allow for that immediate removal. That's something y'all as community associations are going to have to consider. Let's see here. Oh, this is funny. I find it amusing when I encounter a board member who won't share a government issued form of identification with ... the government. So very good point. And that may be a way to explain that to the board member who doesn't want to do it is, look, do you have a passport? Yes. Who issued the passport? The federal government. Who's asking you to report the information to them? The federal government. Technically, the federal government already has this information. It's just in a different department, right? And so they can't share the information between departments unless there's something that statutorily allows it. So we're reporting something that the federal government arguably already has. And I think that's a very good point to make to board members that are kind of upset. This process is ludicrous. How can we get an HOA POA exempt? Well, I know that CAI National, Community Association Institute National, is trying to get some HOA exemption. I'm not sure whether or not there's any traction on that, but it is a federal push. So you would actually have to do a federal lobby to try to get HOAs and POAs exempted. One problem I see with that is defining what an HOA and POA is, because each state has different requirements making you a POA, condo, HOA. So I don't, there may be a way to adequately design the statute. But nonprofit is not enough, because there are plenty shell nonprofits that are engaged in organized crime. What happens if nobody wants to throw their name in the hat because of this new rule? What do we do? So again, it's similar to the process you do when you don't have a board today who's serving on the board. You've got to basically continue with your e-blast, tell them that if they don't act soon, you're going to have to get a court-appointed receiver, which costs thousands and thousands of dollars every month. So please volunteer. Oh, this is a good one. Are ACC committee members considered beneficial owners? I don't think so. I don't think an ACC member is a beneficial owner, because they really don't have substantial control over the financial affairs of the corporation, right? They really just make decisions on improvement applications. There are some ACCs that have more power, but generally speaking, I don't know that an ACC is going to be qualified or classified as a beneficial owner for purposes of reporting. Oh, good. So she said the or. Let's go ahead and go back to that slide, Kyle, on the 20 employees or 5 million in gross receipts. We'll get it locked in here real quick. There we go. Ooh, I've got an and here. So good question. What I'll do is I'm going to confirm I'm going to look at the statute again and confirm it's an and, because I'm showing that all three requirements must be met, by using the term and, but it seems like CAI National may have said or. So I will take a look at that, and if we need to update that slide before it's shared, we will do so. So it's slide 9. The term and requires all three. But if there is an or, it means any one of the three. Again, I feel fairly comfortable in saying it's an and, but I'm going to confirm that nonetheless. Good question. All right. Old board. So the old board really wouldn't be responsible. So it's really just the new board. Now, are the members responsible because the association may be liable? Well, where do associations get their money to pay stuff, including penalties? They get it from the owners. So, I mean, it may not directly impact the prior board members, but it will indirectly impact them. Why? Because they're owners in the community and are going to have to pay an assessment. If a foreign owner if a board member is not a resident, they still have to comply with the CTA. Next question. What about a board of 9 where 5 are execs and 4 are only voting members? Boy, oh boy, that is a good legal question for your counsel. There's an argument that maybe it's just 4. Charging for CTA per association. Again, for our clients, I want to treat this educational. So we will be sending out that information to our clients here in the next week. Has a mechanism for filing been established? Yes, FinCEN has started accepting filings. So there is a system in place through FinCEN. FinCEN. How is filing of the information? Oh, it's an income opportunity for management companies and law firms. Well, this is not the way we want to earn income. I promise you this, because of the liability considerations. Filing the information, click of the button, right? But anybody who receives sensitive data, personally protected information, you've got to store it a certain way. It's got to be encrypted and protected. So again, more liability concerns to think about. The burden is not on the management company and law firm to comply. It's on you, the board. So y'all have an obligation to comply. It is not the management company doesn't have to provide this service. The law firm doesn't have to provide this service. It is legally responsible for you, the board, to comply. So this is not a management company has to or law firm has to. Good question. Oh, the employees argument, the 20 employees, is it employees of the association or employees of the management company? Well, if they're employees of the association, how can they be employees of, or excuse me, if they're employees of the management company, they can't really be employees of the association, right? Because there's an independent contractor relationship there. So that would be hard to prove up. Landscaping committee. These are all kind of out there. Good questions. I don't know about a landscape committee. Again, it's substantial control over money. The website is easy to use. The hardest part is getting a .gov login. Yep. So the process is not overly burdensome. It's just staying on top of it and doing it the right way. Very good point. A substantial was defined in the slides, but you're basically, are you making decisions, financial decisions on behalf of your community on a daily basis as a board of 5? If the answer is yes, you're exercising substantial control. Yes. So the question is, can board members file themselves? And the short answer is yes, there is a way to file your own information yourself. And that makes the company applicant happy because that reduces their liability because they don't have to store that private information. So that is an option that can be offered. And that is it for the questions so far. Any other questions? Perfect. Well, hey. Oh, wait. One more just came in. Does the website give notice that the filing is accepted? Yes, I believe it does. If memory serves, there is an email kind of confirmation that is provided. Well, hey, thank you all so much for listening in and learning a little bit about this horrible law that we have to comply with. And I understand the purpose, and I understand why it's hard to exempt associations, but it's still another issue we have to deal with on trying to get board members on the board. But again, work through it. Get with your counsel, your management company to look at options. We still have 10 months, and we do have that House bill that could push it to January 1st of 2026, which would give us a year and 10 months. So fingers crossed that bill passes so that we have a little more breathing room. But as it stands today, we've got roughly 10 months to file. So Thank you all very much. I hope you all have a good rest of the day and a good rest of the week. Bye, everybody.